For our legal talks, in today's video, we bring you a critical ruling from Allahabad High Court that clarifies a pivotal issue under the SARFAESI Act, whether the reinitiation of SARFAESI proceedings can justify a refund of forfeited EMD, earnest money, under Rule 9(5) of Security Interest Enforcement Rules 2002. The answer is a firm no, and here is why. The background of the case involves a writ petition filed under Article 226 of Constitution of India. The petitioner had participated in a new action conducted by the bank on 29 December 2023 under the SARFAESI Act and deposited 17.49 lakh, that is 25% of the bid amount, as a earnest money. However, the petitioner failed to deposit the remaining 75% of the sale consideration within the prescribed period under Rule 9(4). So later, the bank withdrew the original SARFAESI proceedings and initiated fresh enforcement action on 18th November 2024. The petitioner argued that since the initial SARFAESI action was withdrawn, the forfeiture of his earnest money lacked legal justification and amounted to unjust enrichment. This is what the petitioner argued. Here the legal provision, Rule 9(5) of the SARFAESI rules, Rule 9(5) of the Security Interest Enforcement Rules 2002 states, in case of default of payment within the period mentioned in Sub-Rule 4, the deposit made under Sub-Rule 3 shall be forfeited and the property shall be resold. This rule makes forfeiture a mandatory statutory consequence of failure to pay the balance consideration. So law is very clear. So the court's observations, the division bench of Allahabad High Court, comprising Justice Shekhar B. Saraf and Justice Dr. Y.K. Srivastava, made key observations. The forfeiture of 25% of bid amount is automatic and statutory upon default. Mere reinitiation of SARFAESI proceedings does not qualify as an exceptional circumstance. The court examined the Supreme Court's ruling in the Authorized Officer Central Bank of India versus Shanmugavelu, particularly paragraph 112 and 113 emphasize that equity cannot override explicit statutory provisions. So the key legal principle reiterated statutory finality here, Rule 9(5) leaves no room for discretionary or equitable interpretation unless exceptional, uncontrollable circumstances exist. Bank's withdrawal not exceptional. The court clarified that actions of the bank after default, including withdrawal and reinitiation, have no bearing on the legal consequences of the action purchaser's earlier default. Binding precedent, the court reaffirmed that when the law is clear, court cannot interfere based on sympathetic or equitable grounds. Why the petition failed? The petitioner accepted that he did not pay the remaining 75% in time, could not prove any external or unavoidable factors for his default, relied solely on post-default conduct of the bank, which the court found irrelevant to Rule 9(5). Hence, the forfeiture was upheld and the writ petition was dismissed. So the takeaways, the judgment reinforces that timely compliance with the payment obligations in SARFAESI action is critical. Once forfeiture under Rule 5 occurs, refunds are extremely limited and allowed only in extraordinary situations. Banks' subsequent actions, like reinitiating SARFAESI proceedings, do not dilute the consequences of auction purchaser's default. If you are participating in e-action or advising the clients, make sure all payments deadlines are strictly adhered to. There is no second chance under Rule 9(5). If you found this video insightful, don't forget to like, share, and subscribe to RR Legal Talks. For more legal insights and updates on the SARFAESI Act and IBC, hit the bell icon so you never miss an update. We have two channels, RR Legal Talks and RR Corporates. Thank you.